The new Companies and Allied Matters Act 2020 provides for remote or virtual general meetings, provided that such meetings are conducted in accordance with the Articles of Association of the company, which contains the rules and regulations guiding the internal management of a company. This will facilitate participation from any location at minimal cost. This is especially relevant today, given the disruption caused by the COVID-19 pandemic to business operations around the world. In addition, there are 14 other provisions in the new legislation, all of them carefully engineered to promote the ease of doing business environment in Nigeria. Joining us now to talk about these additional provisions and indeed address the anxieties of businesses in Nigeria regarding the Corporate Affairs Commission is Ozofu Latunde-Ogiemudia, partner at Udo Udoma and Bello Sage. She chaired the Technical Advisory Committee that prepared the initial draft for the amendment of the Companies and Allied Matters Act 2020. Welcome to the program, Ms. Ogiemudia. Good morning.
Good morning. Thank you for having me.
Good morning. Good to have you on the program. Well, many commentators have said that CAMA 2020 is a major breakthrough. 30 years after, we have a revised Company and Allied Matters Act. And as someone who was involved in the technical drafting of that particular act, I would just like you to take us through the highlights and then tell us about the significance of this amended act.
Thank you very much. The Companies and Allied Matters Act 2020 is indeed a very welcome development. That's because it replaces the Companies and Allied Matters Act 1990, which we had for 30 years without major amendment. And so what happened was that as the world moved forward and digitalized, our companies were stuck with law and regulations made pursuant to that law that couldn't adapt for the digital age. And we all saw that when the pandemic broke out and physical meetings were not possible, the regulators had to come up with creative ways in which companies could continue to meet. So what we aimed to do with the Companies and Allied Matters Act was to enable companies operate as easily as possible and also recognize that electronic means of communications and virtual meetings are now the reality of the day. You've already mentioned the ability of private companies to hold virtual meetings. That's true, and that's one of the innovations of the Act. In addition, the Act, for instance, says that any filings that need to be made at the Corporate Affairs Commission can be made electronically. And that's a major breakthrough because prior to this Act, every document to be filed at the Corporate Affairs Commission had to be a physical wetting signature. And so, for instance, where you had a company that had one director outside the country, you'd have to courier the document to him or her to get it signed and then courier it back for the Nigerian resident directors to sign and then make sure that single document is what you submit at the CAC. So it was a lot of cost and just a lot of hassle to comply with simple regulatory requirements like filing of annual returns, etc. Other innovations of the bill to make business easier is, for instance, the introduction of single member and single director companies. This is available to small companies and also to private companies. Private companies can now have a single shareholder, but if they're not a small company, they must have at least 2 directors for increased oversight. Also, the net for what comprises small companies has been increased. So previously, a small company, in addition to other criteria, was one that had annual turnover of 2 million and net assets of 1 million. But right now, it has been increased in the CAMA to a company that has annual turnover of not more than 120 million and net assets of not more than 60 million. So that will bring a lot more companies into the net. And as we all know, small businesses are really the engine of economy in this country. And so when you qualify as a small company, what that means is you do not need to have a company secretary, you do not need to convene annual general meetings, you do not need to audit your accounts. So you prepare your accounts and file your annual returns at the Corporate Affairs Commission yourself. What we anticipate is that as small companies grow and maybe take on investment from financial institutions and equity investors, they will then strengthen their governance processes, increase the size of their board, maybe take on additional shareholders. Other innovations of the Act include increased transparency as to who owns the company, just to prevent asset shielding. Also before in the CAMA, the company couldn't recognize any trust held on shares, but that's now possible, just for, again, increased transparency and ownership of a company. Public companies now must have independent directors, at least 3 on their board. Again, that's just to increase the oversight for public companies. Maybe I should stop there.
Okay, there's a lot. I mean, 870 provisions in all. But, you know, talking about the small businesses, some would argue that this is fantastic. A lot of exemptions for them. I mean, auditing, secretary, and all of that. But does it not create an avenue for unsavory practices and arbitrary practices? But then there are also questions as regarding other provisions that have raised questions. For instance, who actually controls partnership? Who has control over partnerships? This is coming over a decade after states like Lagos, you know, incorporated limited liability partnerships into their partnership laws in the state. Now that CAMA has recognized entities such as limited liability partnerships and liability partnerships at the federal level, isn't that creating a tough war between federal government and state government? So what was the thinking behind this, and who controls these partnerships?
Okay, let me start with the issue of the reduced oversight on small companies and whether that will lead to maybe fraudulent practices. The reality is that even under the CAMA 1990, while companies were required to file returns, as the CAC itself admitted, sometimes the company will just get some auditor, prepare accounts which may or may not be accurate, and submit it with annual returns. And sometimes when the CAC is going through the filings, they'll see that there's a completely different thing stated in the accounts from what is stated on the annual returns form. And so people were just submitting documents to comply. I think that, like we said, for small companies where you have, it's essentially a proprietor running his business, what the Act aims to do is encourage these businesses to come into to incorporate, rather than operating outside the system of companies. And what that does for them is that it makes them eligible for funding, so for bank funding, and also for investments from other potential investors. Like I said, when you're a one-member company or single director, sole business essentially, you're running your business. You are motivated by your desire for your business to grow and improve. But again, you can only grow to a certain level by yourself. And when you get to a point where you need to take in more equity and or debt financing, we expect that at that point, the investors that are looking to invest in these businesses will insist on certain minimum governance standards that will make these small companies have to improve on their board capacity and also on their shareholder arrangements. In relation to partnerships, there's no doubt that the states are competent to regulate partnerships. But what the Constitution does is give the federal government the power to regulate incorporated entities. And incorporated entities are the only ones that can have separate legal personality. So in relation to general partnerships, which we've always had in Nigeria, and to limited partnerships, where there's no separate legal personality of the partnership, those are certainly within the competence of the state. I think the debate arose in relation to limited liability partnerships, which take on the nature of companies, which is like having separate legal personality. So the partnership is a person. separate from the members, from the partners, which is not the case with general partnerships and limited partnerships. And so which is the reason why we thought it should be regulated by the CAMA, the limited liability partnerships. In addition, yes, Lagos State is one of the states that has a partnership law and has had for years. And in the course of my practice, certainly all the partnerships we've set up have been set up under the Lagos State law. But one of the questions that arose in relation to those partnerships, for instance, is where the limited liability partnerships transact business outside of Lagos State, will their limited liability nature be recognized in other states that do not have similar laws? That was one of the things we wanted to address with the CAMA.
Right, thank you so much for that. I want to talk about small businesses, and I want to know provisions in there for small businesses, because obviously in the past 30 years, the landscape of businesses have changed from the hitherto brick and mortar understanding of businesses to things like fintech, to things like Internet of Things businesses and other things like that, to the tech space in Nigeria. I mean, what are the laws in that provision for these businesses?
Okay, so the Companies and Allied Matters Act provides a generic framework. So it's not specific as to maybe fintech or any particular industry that's seeing a lot of growth right now. But for instance, one of the things that the Act does is expand the size of the CAC board. Now, under the previous Act, the CAC board had representation from the private sector, for instance. It had representation from the legal profession and the accounting profession. But with the current Act, the National Association of Small and Medium Enterprises has a seat on the board. In addition to that, the Institute of Chartered Secretaries and Administrators has a seat at the board. They are the main customers of the CAC. And the hope is that with the NASME being on the board, there is a voice for small businesses in relation to the drafting of regulation and policy to guide companies, so that small companies are always taken into account when these policies are being drafted. Because that was one criticism of the previous Companies and Allied Matters Act, and also the framework for regulation of companies, that it didn't sufficiently recognize the difference between small companies. They were regulated just the same way as PLCs, despite their limited capacity to deal with such a heavy burden of regulation. So again, there are other things in the Act that recognize just the electronic nature of things, so the ability to do your virtual meetings, the ability to submit documents electronically, the ability to dispatch notices for meetings by email, which was not possible before. You always had to post your notices and courier them if the person was out of the country. So those are the sort of things that the Act has done to ease the ability of small businesses to comply without unnecessary cost and time expended on regulatory compliance.
Well, I mean, there have been reactions to CAMA 2020, particularly from the tribe of general overseers of churches, who claim that in this new Company and Allied Matters Act, there is an attempt to control churches and curtail religious freedom, because the Registrar General of the CAC has been given powers to oversee churches and charity organizations in the public interest, particularly with regard to the composition of the trustees. To wit, if a church or a charity organization is found to be engaged in certain activities that are engaged public interest, then the Registrar General of the CAC can move in and appoint new trustees. Now, what's your response to that? Is that a big issue that we need to worry about?
Okay, thank you for that question. I saw some of the debates that have been going on about that provision. I think that I should make it clear that the provision on regulation of incorporated trustees is not targeted as any particular form of incorporated trustees. Maybe that this is also a part of our law that we need to look into further, because the same structure that is adopted by most churches and religious organizations is a structure adopted by non-government organizations, commonly called NGOs. And so NGOs are, a lot of them incorporate as incorporated trustees. Some are companies limited by guarantee. Incorporated trustees have, prior to the CAMA 2020, not been regulated per se. So, and I think the mischief that that provision sought to address was in relation to non-profit organizations that maybe receive donor funding and are not accountable for it. And I think we all have heard of instances where non-profits take donor funding, don't account for it, misuse it, and contribute to putting this country in a bad light. I personally did not have any experience of these provisions being targeted at churches or religious organizations. And I think it's just because our law currently has a limited framework for regulating charities. Like one of the arguments had pointed out, in some jurisdictions there's a separate Charities Act. Maybe that's something we should consider, and so we're not lumping religious charities with some other types of non-profits. But again, I think that it's good, the debates that the Companies and Allied Matters Act has thrown up, even in relation to this matter. Some of the areas of concern might be able to be clarified with regulation, and where that's not possible, the law should be a living being, a living document that is constantly reviewed and constantly amended so that it fulfills its purpose. And where there is an unintended consequence, that can always be addressed by amendments. So what I would say to that is that it's still early days. We all are reading through this act. Like you said, our technical advisory committee submitted its report in 2018. This is 2 years later. So this act has been many years in the works. And so if the version that was signed by the president, we're all reading through it and getting to understand it. I think that we should continue the debate. And I think that apart from the fact that the CAC will need to make regulations under the act to clarify areas that might not be clear, I think that where there are any areas that have been identified where there are unintended consequences, then we are all part of the legislative process. We should all take an interest in it and feed into bills when they are being debated and called for, and when there are calls for public opinion. And I think that on the Companies and Allied Matters Act, the door is never closed. And unlike what happened with the previous act, where we had no major amendments for 30 years, I think we've learned from that experience, and it shouldn't repeat itself. So even this act, I think that right now is the time to identify any areas where it might need amendments or where we might need regulations to clarify, and try and deal with that in the most efficient manner.
Indeed, because there are some who also question the Section 26, which talks about those companies with limited guarantees, and they talk about the overreaching influence of the Attorney General of the Federation, whose consent is required in, incorporation of those companies. But I also want to ask you about tax, because initially I asked you about, who actually should have a say over partnerships. But there's also the argument of taxation. So with CAMA, analysts, say there's a likelihood of more businesses registering as corporations who should pay tax to the federal government. However, the states also have a problem with revenue, and over the years, they've had these businesses register as non-incorporated companies. So is this also a tax war brewing between the federal and the state governments? And what are your thoughts on this?
Yeah, so I'm not aware of any tax war brewing in relation to this issue. Under the previous CAMA, small businesses could register a business name, so they'll be unincorporated, but just have their business name protected at the Corporate Affairs Commission. That has always been within the Act. So in as much as those entities are unincorporated, they do not pay companies taxes. And so the individual behind that business name will pay personal income tax to the state where the individual is resident. And I don't believe that that has changed. I think what might have changed is that the new act creates a more encouraging environment for those unincorporated businesses to incorporate. And so if those businesses then choose to incorporate by setting up a company, maybe it's a single shareholder and single director company, that will take them out of the tax, take the entity that they set up out of the state's tax net and into the federal system. But individuals continue to be taxed under the Personal Income Tax Act, and those taxes go to the state. So that hasn't changed.
All right. I just want you to clarify this for me. The part that we'll go for a quick break. We'll come back and we'll talk some more about this, and then I'll ask my question. Thank you so much for your patience. All right, welcome back to the Morning Show right here on the Rise News Channel. We've got Ozofu Latunde-Ogiemudia, a partner at Udo and Bailey Osage, who chaired the advisory technical committee that prepared the initial draft of the amendment of the Companies and Allied Act, Matters Act 2020. That's CAMA 2020. It's a pleasure having you here. I'd like to talk about, just explain this to me, the act that talks about, the part of the act that talks about if you're a director in a company, you can't be CEO or chairman of that company. I mean, how does that work? Because we have a lot of people that are directors, and at the same time, they still manage that.
Okay, well, no, what the Act says is that if you are the chairman, you can't be the CEO of a company. So the chairman is, he has to be a director first to even be appointed as the chairman of the board, and the CEO is usually also a member of the board. So it's not, that provision is new to the CAMA, but it's actually not new to corporate governance in Nigeria. It's in the code of the Securities and Exchange Commission, and we have several other codes of corporate governance that are already in force in Nigeria that say so. So they say all it does is put in the statute the separation between the position of the chairman and the CEO of companies. So before now, if you weren't regulated, you probably could do that. Private companies could do that. Public companies, no, because they were regulated by the SEC code. But what the CAMA does now is that they make that cut across the board. So if you have a board where, and it won't apply to small companies that have only one director, but where you have a board of directors, it means you need to choose one person as your chairman and choose a separate person as the CEO. So the entrepreneur, the driver of the business, will probably be in the CEO role, and then we'll have to identify.
But the fear normally that a lot of people cite for doing this is the fact that on the board you can be usurped. Hello, can you hear me?
Well, that happens. Yes, I heard you. On the board, you can be usurped. Yes, but that happens as the company grows bigger. So in a small company where you are maybe two directors, it'll probably be you, the business owner, and maybe your parent, your spouse, your sibling. And that's okay as far as you are the one funding your business. You can choose your directors as you deem fit. I think where you start taking in third-party investment, so maybe you bring in a private equity investor, they will want a say in how the company is run. They want seats on the board. And I think it is when you get into those sorts of arrangements that you might find as your company grows that the other directors might feel there's a need for another CEO to come in and move the company in a different direction. But again, from inception, you are in control of your company. You are in control of the point at which you say, I can't do this alone. I need to I want to open 100 branches, and I need to get outside funding for it. And in order to do that, you have to give up something, because nobody is going to put money in your business and leave it to you to run it as you deem fit. But I think the point I want to emphasize is that nothing is forced on entrepreneurs. You can keep your business close-knit and within you and your family unit for as long as you can drive your business that way. And for some people, they can drive it all the way, running it, funding it exclusively by themselves. But for some others, you can't. And when you get to the point where you want to expand and you need additional financing, you will have to come to terms with the fact that you might have to give up some of your control.
Well, what you just clarified is Section 265 of the Companies and Allied Matters Act, and your explanation makes sense. But I would like you to also help us clarify Section 307, which limits directors from the number of boards on which they can sit. Section 307 says you cannot sit on more than 5 boards of public companies. What is the mischief that the law is trying to address in that regard? And then secondly, I would also like you to comment on the Corporate Affairs Commission, the CAC, its recent policy in terms of the delivery of certificates of incorporation, which has been resisted. The CAC wants to adopt mail delivery, courier delivery of certificates in the season of COVID-19 and after. That some stakeholders say, no, this is not working, that the CAC is inefficient. All of this within the context of the attempt by the government to promote the ease of doing business.
Okay. So on the first question, yes, there's a limitation on the number of seats that a person can occupy on the boards of public companies. And that limit is 5. So the reason behind that provision is really capacity. Being on the board of a company is a demanding role, and most people do that in addition to their day job, whatever it is that they do for a living. So in addition to the usual demands of your job or your business, when you take on a seat on the board, you are expected, directors are expected to act in the best interest of the company. So that means you need to be aware of what is going on in that company where you sit on the board in order to act in its best interest. When you're on the board of a public company, that's a more regulated entity. They have management accounts coming out maybe quarterly. They have returns to be filed with regulators. And so the volume of documentation that directors on these sorts of companies have to go through is significant. And I think even for one person to sit on 5 boards of PLCs is asking a lot. But where you feel you have the capacity, it's always voluntary. Nobody can foist it on anybody. Where you feel you have the capacity, I think the law draws the line at 5 because it was just felt that it would be almost impossible for you to be equally efficient, staying on top of all the developments in relation to 5 PLCs and being able to contribute in that role as a director as you should. So that was the reason behind that amendment. I would also like to point out that for the directors that have the capacity to do 5 PLCs, there's no limitation on private company boards. So such directors may also be directors in a number of private companies. So yeah, so PLCs were the focus, and it was just so that those that sit on the boards of PLCs can give those companies their attention and the benefit of their knowledge and experience. Sorry, your second question.
The second question was about the CAC and its new mail delivery policy.
Yeah. Okay. Yes. So. I think that if we are serious about moving forward, then we need to embrace change. I saw the CAC's announcement as a welcome change, especially in this time of COVID. Lawyers had complained that when the CAC reopened after the initial government lockdown, they spent hours sitting outside, waiting in the car park, waiting to be attended to. And so the CAC thought that a way to respond to this and also to deal with just the issue of people having to physically come in and out of their offices in this digital age is to try and reduce the functions that you have to come into the CAC to carry out. And so if you've submitted all your documents and your company is incorporated, and they've said that they're going to use a reliable courier service to get your document to you, I honestly struggle to see why we shouldn't try it. I think that if the CAC dispatches documents to you and you don't get them, then the CAC is responsible for that and has to reissue them to you. But if the documents get to you in the comfort of your office or your home, I honestly struggle to see what is the issue. Some have argued that it takes jobs away from lawyers, but you know, I'm a lawyer, and I think that as lawyers we should there's so much for lawyers to do beyond collecting documents at the CAC. Even helping the clients put together their application and file it at the CAC was part of what a lawyer could do. And there are other parts of business, advising on transactions and agreements, etc. So I think that we should embrace change, and we should encourage the CAC in this digital drive.
On that note about embracing change, which is the only constant that we should always embrace. We want to thank you very much, Ozofu Latunde-Ogiemudia, for joining us on the morning show. Thank you very much indeed.